Guys, Dimitry Erudaitius. I'm an attorney in the state of California, and I am making the first of hopefully many videos to help you guys in court and also give a lawyer's perspective on a lot of the other things that are kind of going on in our world. For instance, maybe on our next video, we'll talk about the Bill Cosby, Britney Spears kind of scenarios. But for today, we're just going to talk about the top 5 things that I see self-represented litigants doing in the courtroom that are probably bad and hurting your case. So we're going to do the, kind of basic stuff, and a lot of you are going to be like, why did I need to listen to that? I didn't need to hear that. Obviously, I knew that. The reason I'm going to say them is because I see a lot of people doing them. Number 5 on this list is going to be dress code. Guys, that one's a pretty simple one. Everyone knows to dress appropriately from court, but you'd be surprised at how many people still walk into court, or even more so now with virtual hearings, are showing up to court in things that are inappropriate. Look at the way I'm dressed today, right? I have a jacket, I have a shirt on, but I would never show up to court this way. As a lawyer, this would be completely inappropriate. I make sure I have my tie on and my full suit every day I go into court. As a self-represented litigant, you don't have to get that gussied up, but you definitely do want to wear something that presents professionally. Just like you would go to a job interview. You're not going to show up to a job interview in, your shorts or something you're going to wear to the beach, right? The reason we don't do that is because we want to be taken seriously in court. We've got a lot of serious issues going on. The last thing you want the judge to do is be distracted by what you're wearing. All right. So number 4 is don't talk over anyone. Everybody has a time to speak in the courtroom, and the judge is going to direct that and tell you when you can and cannot speak. It is very hard for self-represented litigants not to talk over people, and it's probably because you hear the other side talking and you hear them lying. They're lying out of their teeth, and you know it. You're like, hey, judge, objection, don't let them say this stuff, don't believe them. Just wait your turn. You're going to get your turn. The judge will listen to you. Now, if you feel like you're not going to get heard, it's probably a good idea to kind of sit back, give the judge a second. He might be ruling in your favor. Kind of feel it out. Let him speak a little bit. Try to see where it's going. Be like, Your Honor, may I address what opposing party said? That's a great way to kind of interject and be respectful about it. Don't just say, hey, I need to say something. It's Your Honor. It's always Your Honor. Always start with Your Honor. Your Honor, may I address what the opposing party said? So there's a line for you that might help you in the courtroom. Number 3, don't play lawyer. The judges know you guys are not lawyers, and I've seen a lot of very smart people who have studied the law, and they think they know the rules of codes, and they go in there and they say, Your Honor, objection, they're citing codes. The judges generally do know, the area in which they're sitting for. For instance, a family law judge sitting in family court is aware of family law codes. For you to sit there and cite codes to him isn't helpful. So the other thing you don't want to do is, Your Honor, objection, I'm doing this, but I want to say this, the other party's lying. Objections have legal grounds, and when self-represented litigants yell objection for no reason, the judges kind of just have to sit back and go, you're wasting my time, please don't object unless you have a legal objection. That's why it's really best to have a lawyer in court. But if you don't, kind of just wait your turn. You're going to be able to say what you need to say, and you'd be surprised 90% of the things people are bringing up that they think are important are generally important when the judge is making their decision. Number 2, not to do, surprisingly enough, is don't tell the judge they're wrong. If the judge is wrong and you tell them that, it's not going to help you, right? I've seen a lot of judges go, oh, you think I'm wrong? Okay, I'm going to make it worse for you. All right, so don't do that. Simple, easy. You're getting a bad decision. You're going to have to try to address it in another way. Again, seek counsel. It's the best way to do it. And number 1, not to do in court, is show up late. Why is that number 1? Surprisingly enough, again, a lot of people do show up late, and all of a sudden the judge will make a decision because you weren't there to argue your case. You got to be on time. When I say on time, you got to be 10 minutes early. If you're not 10 minutes early, you are definitely late. You never know when a judge is going to call something, move something around. You can be sitting in court 3 hours, but it's better to be there for 3 hours than miss your case entirely. All right. Some other things I wanted to leave you guys with are some kind of phrases and terminology that might help you navigate the courtroom a little bit better, and that's kind of speaking professionally. So instead of saying things like, Your Honor, I thought, I think, it, as the law lawyers will say, my contention would be, our contention is, our position is, rather than saying I think. It's very opinionated, and what you don't want to do is be very opinionated in court. You want to sound like you're, giving factual reasons and evidence that are backing up your points. So I would contend, my contentions are the position that I'm trying to represent is, right? If you had something with another party and you agreed on it, use the word stipulation. Don't say we agreed, Your Honor. It's it's a lot more binding, and it sounds more binding. You said the parties stipulated to, and now you're sounding more like a lawyer. And I know I just said don't play lawyer in court, but these aren't things that are necessarily playing lawyer. These are just sounding a little bit more professional when you're in the courtroom. The last thing that I'm actually going to leave you guys with is the facts that you're presenting, the truth. Is it okay or not? How much should I say? How much should I not say? That's probably the most nerve-wracking thing to do in court. That one's a very hard question to answer. It's difficult because what you should and should not say in court entirely depends on your case. What I find is that if you don't know what you're doing, less is more. You know, let the judge navigate it. He's going to ask the questions to help him get to where he needs to be, right? Or she needs to be. You don't want to give too much information and all of a sudden the judge changes their mind because they didn't realize that you were thinking in a certain way or doing certain things that are going to influence them in a negative way. So less is more. Try not to say too much in court. Let the judge navigate what's going on. Those people who become very opinionated and are yelling, screaming, getting passionate, obviously, you know, it's difficult to be in court. These are life-changing decisions that are often before the judges, but you can't let your emotions overtake you. You got to be logical about how you approach it, and it never helps screaming, yelling, and going about it that way. So those are some recommendations for you. Short video, but leave some comments, and hopefully we can have a question and answer. If you got an upcoming court case, I'd love to, you know, help guide you through those situations. Once again, my name is Dimitry Erudaitius, and of course there's always a disclosure. All of the things on here cannot be taken as legal advice. You can read the little disclosure at the bottom. There's no attorney-client privilege, but I hope this helped. All right, guys.